It's a bad policy to allow the population of a country to freely own guns. What results is a lot of random death and a lot of fear and nervous police. This leads them to be afraid of the average citizen and to shoot before asking questions. This is why many countries in the West have strict gun control laws. For example, Canada, the UK, Sweden, Australia, Germany, and Norway all have strict gun control laws. All of these countries have an average of approximately one gun death per 100,000 people. The US, with almost no gun control laws, has approximately 12 deaths per 100,000 people. That's a whopping 12 times the size or the average of the above 6 countries who have strict gun control. Hence, taking the US population into account, about an extra 37,000 people are killed in the US each year unnecessarily. That's 370,000 more every decade, shot and killed unnecessarily. You think that even after 10 years, those families are still not grieving and suffering from the loss of their loved ones. 370,000 families, 370,000 groups of friends and loved ones, workplaces, sporting teams, and local villages. What has grown up in the US is a culture of death, an acceptance that your loved ones may not return home because they have been shot by a random person. The country and western band Federale, in the song Almeria, a song about an outlaw and a bounty hunter, sings, "But I can tell you, son, he is a guilty man indeed. And when I get him in my sights, I'll make that mother bleed. Yeah, I'll put him in the ground." There is a brutality in these lyrics that point to a brutality in the psyche of the US. Although the man in the story has committed a crime, presumably, and may deserve punishment, there is a ghoulish celebration of the death. Yeah, I'll put him in the ground. It is because of all these extra legal deaths and all the other shallow graves that we are discussing the gun culture in the USA today. And where else would you start if not the Second Amendment of the United States Constitution and the failure of American leadership? The particular failure I'm talking about is the Supreme Court's flawed interpretation of the Second Amendment in the 2008 Heller case, specifically that it protects an individual right to keep weapons ostensibly for self-defense. So, to the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay, firstly to the grammar and the analysis by Professor Frank Bergson. The grammar of the sentence doesn't announce a purpose for the right to bear arms. It announces when and why the right shall not be infringed. In grammar, absolute constructions never modify the subject of the sentence, but always the predicate. The Second Amendment doesn't say we can't own guns to go hunting or even to defend ourselves, but the right for those purposes can be infringed. You can have a license, for example, system. The Second Amendment uses the absolute construction, which was used in Latin and is still used in English today, to give us the reason and occasion for the main command of the sentence, when and why the right to keep and bear arms for a well-regulated militia shall not be infringed. It is about the Constitution giving the states the right to establish a militia. They were concerned that the new federal government could misuse its power. They wanted to retain the right to defend themselves. To establish a militia in 1791, a state would have to call up men with guns, hence the inclusion in the clause of the right for the people to keep and bear arms. But this right to keep arms is expressly given to serve the purpose of the state to raise a militia. That right is now unnecessary and obsolete. Unnecessary as the United States is now the greatest military the world has ever seen, with over $900 billion per annum spent on the military, with 2 million soldiers. No individual state is going to raise an army to take on this colossus. It is obsolete as even if a state wanted to raise a militia, it would equip itself with military weapons and a trained standing army, not call up a ragtag militia. The entire clause is obsolete. Also, there is a structural error here. In federations, the states and the federation are not both given the defence role. That makes no sense. It is also an error as the amendment is self-contradictory. An unfettered individual right to keep and bear arms is in conflict with the right of the state to preserve its security. Many people will be loyal to the federal government, not the state, and there will be many misfits and outlaws and mad people and nonconformists and conscientious objectors who will thwart and act against the state. Also, when the Constitution was enacted, there were only 13 states. Since then, 37 more states have been added to the Union. Any or all of these states could fight on the side of the federal government against the free state in question. You are giving them the right to raise a militia as well. That is definitely not conducive to the security of a state. In this amendment, the states have actually been given the rights of standalone countries. This is an anomaly in the US Constitution. It is a structural flaw. Having acknowledged that, suffice to say, some states want to have the right to defend themselves if necessary. The way they would do that was call up a militia, hence the second clause in this single sentence amendment. People talk about the amendment being about individual gun rights, but this clause is not about that. It is essentially about saying to the states, you have the right to get up your own militia, your own military, because we're going to say that in order to be a free state, you need that element to be able to maintain your security as a state. So the first clause in the sentence is really what it's all about. It's the purpose of the amendment. It's about getting a militia together. A key point here is the clause is addressed to the states, not to individuals. Now, the second clause says that the right of the people to keep and bear arms shall not be infringed. The amendment is saying you need to be able to have a regulated militia for your security, for the security of a free state. And then thrown in after that, we know that in order to do that, in 1791 we're talking, you would need to call up men with guns. So we are going to say that the right of men to keep a gun for the purpose of joining a state militia should not be infringed. The section is about an organised militia, and they have used terminology to emphasise this. They could have just said a militia being necessary to the security of a state, or a regulated militia, but they've gone another step and said a well-regulated militia. They are really trying to clearly make the point that this is about a state organised army. A legislative drafter would just write militia unless instructed to emphasise the professional, martial nature of the militia being contemplated. To assemble and organise troops, a well-regulated militia. Such a strong emphasis on it being a state-run militia. It was not to be a ragtag militia run by individuals. To the states, yes, we would expect you to be able to call up those members of your population who would qualify to serve in a state militia, an army. And in 1791, they would bring their guns with them. So the people have the right to keep arms, but only for the purpose of bearing arms in a militia. It is a right for the state, and the state is a political entity, a polity. And in this case, it is a majoritarian democracy. These policies are described as being ruled by the people, which means the majority. Court cases refer to the people versus this person or that company. We the people inevitably means the majority of the people. We the people in the Declaration of Independence, for example. Not all of the people. It can't mean all of the people in the context of security, because some of the people are seditionists and traitors, and others are not of a stable mental disposition or personality. The people is a description of a polity, not a description of individuals. It is not establishing an individual right. That's a very important point. In that knowledge and with that intention, the Second Amendment is saying the federal government wouldn't be able to take away the right of these potential militia members to keep guns. But we are talking about potential militia members, not any individual, especially not one who would not qualify to be in a militia. Individuals had the right to keep arms in the first place. There was no prohibition on owning guns. There was no need for a new law to protect gun ownership. It didn't require a special clause in the Constitution to protect gun ownership. Hence, the Second Amendment was not for the purpose of guaranteeing individual gun ownership. It was for the state to have the right to get up a well-regulated militia, which is exactly what the clause says. Now, why are we saying keep and bear arms? They could just have said keep arms, because to bear arms is exclusively, right throughout history, a military phrase. The people have the right to keep arms so that they can bear arms in the service of a militia. So the state instituting A well-organised militia means that the state can make regulations as to every aspect of the militia. It's a well-organised militia. It's an army. Militaries always have strict rules and regulations around the handling of guns. The state would employ generals to run the army, and the militia and generals, more than any other institution in society, are very control-orientated. They control everything, all the equipment, all of the armaments, all of the training, all of the strategies, etc. It's a very, very controlled situation. Now we're witnessing the modern day effect of the Supreme Court's interpretation of this clause, which has been more guns than people in America. There's about 400 million, apparently, guns in America, and huge amounts of mass shootings and extraordinary gun violence and gun deaths in the USA. The effects of this is an ongoing catastrophe, and it's just an epic crime that a country is allowing such freedom for its individuals to run around with these death machines. It's just extraordinary, and it's not necessary for the security of the country, nor is it necessary for the security of a state, and nor is it necessary for the security of those individuals. And the states don't need individuals to own guns to defend it against the federal government with its 2 million professional soldiers. The guns that individuals own are only going to be used against each other, and that is exactly what happens. The idea that having a gun is the best form of self-protection is a delusion. The person bursting into your house, knowing that you may have a gun, is going to shoot you first before you even have the time to get your gun out. They will have the element of surprise. People in a heated situation are going to murder each other rather than punch each other in the nose. Happens all the time in the USA. You know, down at the 7-Eleven, a fight over a car park can turn into a death rather than some lesser injury. Accidental gun deaths happen all the time. Problematic children shooting their classmates happens all the time. Crazy haters and demented people in the community who want to go and slaughter large numbers of people in churches happens all the time. And in nightclubs and shopping centres, it's such a catastrophe. It needs to be addressed, and I think that the fact that the leadership in America has not addressed it is beyond shameful. It demonstrates a level of deep corruption. Corporations who make guns don't care, but you would expect the statesmen, the government, and the leaders of society, the Supreme Court judges, to care or to understand. It would have been so easy for the Supreme Court to interpret this amendment differently. Any lawyer could easily interpret this as being a clause where conditional gun ownership or laws around gun ownership and licenses could be enacted. Instead of standing up and being true leaders, the Supreme Court decided that the first clause in the amendment was obsolete, and the second clause could now be interpreted as a standalone constitutional amendment giving every individual the right to keep a gun, not to join a militia, but for personal security. It's extremely embarrassing that they made that ruling, especially at that level. The Supreme Court could easily have ruled that this clause was about the states having the right to a well-regulated militia if they needed it. The idea of a second part of the clause that they would need individuals to keep and bear arms in order to satisfy that requirement is nonsensical in the modern era. Unregulated individual gun ownership does not enhance personal security. It reduces it. All countries with strict gun control have far less gun deaths. That's been established by study after study, by criminologists and by the actual experience of countries with gun control. There's no doubt about it whatsoever. Gun culture is a kind of madness. That's why the rest of the Western world doesn't allow it. It's a chaotic dystopian situation. It's the stuff of third world warlords and drug gangs and bands of preppers and nutters hiding out in the woods. To respond, police are forced to run around like a military, trigger-happy, shooting people if they put their hand in their pocket. They say that the mentally ill or criminals cannot own guns, but in the US, often the way we find out if a person is crazy or a murderer is when they kill people with a gun. Go figure. You say to the family, that they shot your wife or your child. We now know that they shouldn't have a gun and they're all locked up. So, thoughts and prayers, I guess. Your security is far better if unauthorised people, your neighbours, your work colleagues and people from other states don't have guns. With the Heller ruling, the Supreme Court was in error. They went even further than any reasonable interpretation would warrant. They ignored the first clause in the sentence, which was the signature clause, and they say that they are originalists. They then enhanced the second clause by trying to increase its meaning to individual personal security. This was nothing short of judicial activism, which they always condemn. The hypocrisy was astounding. I was wondering how that could ever have happened until recently when it became clear. I thought it was only politicians that were being paid, bribed by large companies. It turns out that the Supreme Court justices are also on the gravy train and being bribed and paid for and living the high life. There is your answer. Follow the money. They have a serious character problem even in the US Supreme Court. This massive failure of leadership and the consequences have been devastating for countless families. The Supreme Court should have stood up to the gun companies. The people were relying on their judges. They should have said, no, you can't go there. We'll allow you to sell guns for farming and sporting and military and licensed security companies, but you can't profit from the loss of countless lives. You can't make blood money. It's courageous leadership that stands up and says, no, that is where the line is drawn. You can't have those extra billions of dollars from unlimited gun sales. You can't have the deaths of school children, the deaths of 40,000 citizens every year. This is where it stops. That's where the line is. There is a limit to the greed. Where is the leadership? The Supreme Court has taken a section of the Constitution that is expressly about security and interpreted it so as to deliver less security to its citizens. I don't think I've seen a better example of negligence or of legal malpractice. Unfettered gun ownership does not facilitate the security of a free state. An unfettered right for every individual member of the public to own guns runs contrary to the right of the state to ensure its security. A state's security is both its general security and the security of its citizens. Mass gun ownership does the opposite. It makes the citizens insecure. It causes the death of tens of thousands more than in those countries who have regulation of gun ownership. It causes insecurity. Children are asking their mothers if they will die at school, but the amendment's purpose is stated to be security. So how can the Supreme Court make up a second clause that defeats the first clause and the intention of the whole amendment to provide security to its citizens? That's what we're talking about. This must have been either the most incompetent or deeply corrupt Supreme Court. It has sacrificed the lives of many children every year on the altar of the gun industry. We need to say to them, what have you done? Finally, if the Second Amendment was about individual gun ownership, it would not be lumped into a section together with a statement about the security of the state. They would just have written, all citizens shall have the right to keep a gun. That's not what they did, because that's not what they intended. A separate sentence could then have stated that the states have the right to raise a militia. Putting gun ownership on a subordinate clause, I mean, it's not strictly a subordinate clause, but it's the second clause in the single sentence amendment. Putting gun ownership in that second clause to the clause about the state's right to raise a militia and loading it with military terms like bear arms and general terminology like the people clearly means the right to bear arms under the control of the state. In other words, gun control. One last argument by Professor Frank Bergson. The Justice Antonin Scalia failed to recognise the grammatical construction of the amendment. The words on the page don't guarantee citizens an individual right to gun ownership. They say nothing about a protected right to keep guns at home or in the street for self-defence. In 1791, the grammar of the amendment would be understood to declare the limited circumstances for when and why the right to bear arms can't be infringed. And as we said, that circumstance when the right to bear arms can't be infringed is in the case of people who qualify to join the state army owning a gun, but then at one and the same time, the clause says a well-regulated militia run by the state. So the generals can then turn around and make regulations about the ownership of those guns. But in the modern era, they wouldn't allow them to even have those guns in their house or on the street. So there would be complete gun control. Cases before the Heller case disagreed with the Heller case. In United States versus Cruikshank in 1876, the Supreme Court ruled that the right to bear arms is not granted by the Constitution, neither is it in any manner dependent upon that instrument for its existence. So the right to bear arms is not dependent on the Constitution. It was already there. So it's still already there, but you can have regulations to control gun ownership, lots of regulations, licensing, rules about when and where and how and what buildings and on the street and open carry and everything. That's what they're saying in 1876. The Second Amendment means no more than it shall not be infringed by Congress, not by the states. The states can do whatever they like in gun control, which is different than what the Supreme Court's now saying. It has no other effect than to restrict the powers of the national government. Right, another case. In the United States versus Miller, 1939, the Supreme Court ruled that the Second Amendment did not protect weapon types not having a reasonable relationship to the preservation or efficiency of a well-regulated militia. That point again, and that was in 1939. Thank you very much for listening. It was a fairly long video, and I'll look forward to talking to you next time. Please feel free to like or subscribe. Thank you.